Hello viewers, this is attorney Naresh Gehi. In light of the tremendous demand of a previous segment, Easy Ways of Getting a Green Card, we've decided to have segment 4 of Easy Ways of Getting the Green Card. This time we have another strategy in connection with getting a green card, and this is commonly referred to as cancellation of removal. What is cancellation of removal? The easy way for a viewer to understand this question is if you have been in the United States for more than 10 years, which means if you are living in the United States for more than 10 years, and that can be an unlawful status, which means if you came on a visitor's visa. Let's take an example. You came to this country on a visitor's visa in 1999, and now you have been unlawful in the US for more than 10 years, which means you have overstayed your visa, you're living here for more than 10 years, and you have US citizen children. For example, you have 3 or 4 US citizen children, and you want to get your green card. The easy way for you to consider would be to file an application under Section 240 of the Immigration Act, which is commonly referred to as cancellation of removal for non-permanent residents. What does the law require you to prove? The law requires you to prove that you have been present in the United States for a period of more than 10 years, point number 1. Second, you need to prove that there will be extreme, exceptional, and unusual hardship. Again, I repeat, extreme, exceptional, and unusual hardship to your US citizen children. For example, if you have 2 or 3 children, and if they are 12 years old, 13 years old, 14 years old, and if you can show to the court that they will not be able to settle in your home country, for example, which may be India, Pakistan, Bangladesh, South America, maybe Mexico, or whatnot, if you can show that these children will be unable to settle in the home country, then you can be eligible for cancellation of removal. The leading case law on this point is the matter of Monreal and the matter of Andazola, wherein the courts have made it extremely clear that a person who seeks cancellation of removal will have to show that there will be extreme, exceptional, and unusual hardship to their US citizen children or their relatives. Now, to put it in another way, sometimes people tell me, Mr. Gehi, I just have one US citizen child, but my child is suffering from a very, very, very serious heart condition or some other type of mental illness or physical illness. You may still have a chance, because if we are able to prove to the court that this treatment is not available in the home country, and the US citizen child would die, especially because he will not get the same treatment in the home country, even then you can be eligible for cancellation of removal. Remember, over here the child is very young, and generally courts look upon the fact that if the child is young, he can settle in the home country of the parent, for example, Mexico or any other country. But here, even if the child is young, and if we can show that this particular sickness is very serious and it's going to be literally impossible for the parents to provide the same amount of tender love and care in the home country, then you can still be eligible for cancellation of removal. So friends, if you or any of your friends are interested in pursuing an application for cancellation of removal, I would recommend you to call the law offices of NM Gehi at 718-263-5999 and come in and see me for a free initial personal consultation.